Good afternoon, everyone. Thank you for joining us for this webinar here. This is a webinar by the Florida Bar's Cybersecurity and Privacy Law Committee. We'll be beginning in just a moment. We'll let people continue to log in for a moment. I'll repeat this, but so people know, this is a webinar for CLE credit. We will put the CLE code on the screen in a moment. Um, and that's a single code that you use one time and just attest that you did attend this webinar when you submit it on your Florida bar screen. And that is all you have to do. Wait just another moment as we have participants joining. Thank you everyone for joining today. Right. Well, now let's officially get started. For everyone that is here with us today, again, this is a webinar presentation by the Florida Bar's Privacy and Cybersecurity Law Committee. We are doing these webinar presentations as part of an ongoing educational series to educate Florida lawyers about data privacy and cybersecurity, which for many practitioners can be a bit of an unknown area, but growing in importance that everyone really needs to know. The purpose of the committee is one of its missions is to make sure that there's education for Florida lawyers in these areas, um, and as well to be developing the rules regarding lawyers with respect to data privacy management. And something I do want to highlight here that will even be discussed briefly is that last month there was a recommendation adopted by the Florida Bar for law firms to implement incident response plans. And I will put a link that Jackson Lewis did prepare an article regarding this that could give you a little background on that. And I'll put that link in here shortly. In terms of just webinar housekeeping issues, if you would like to ask questions, please use the Q&A function during the webinar, and that will be monitored. And finally, I just want to say we will have upcoming webinars the rest of this year. Please keep a lookout through the Florida Bar, their means of communication, and we will do additional webinars on cybersecurity and privacy. All right, that is enough of just those basic details of introduction. I'm very happy to have with us here today. We have Joe Lazarati out of Jackson Lewis's Tampa office and Damon Silver out of Jackson Lewis's New York office. These are some extremely bright guys when it comes to cybersecurity and privacy, which is why they are the co-chairs of the privacy, data, and cybersecurity practice at their firm. They assist clients with everything from implementing their privacy policies, helping them develop data management strategies, um, and then whether it comes to the new issues surrounding AI or any other new compliance issues that have come up, they also assist with incident response as needed. And that's my background of getting to see them working on the insurance side and dealing with incident responders. And then also litigation that can come from any of those types of events. Their firm does that as well. So without further ado, I will hand it over to them to teach us today about data privacy for lawyers, specifically in their practices.
Awesome. Thank you so much, Kevin. Appreciate it. And definitely appreciate the Florida Bar and the committee for having us to present on this issue. Happy to be presenting, as always, with my partner, Damon Silver. We do a lot of work in this area, particularly in the professional services space for law firms and other similar types of businesses. Want to welcome you all and thank you for joining us today. The CLE that we're going to have here will address how lawyers practically manage data privacy and cybersecurity risks that they face in their day-to-day practice, whether they realize it or not. And particularly want to, and we'll give mention throughout concerning the applicable Florida bar rules for professional conduct as it relates to privacy and confidentiality and so on. We're going to try to emphasize some practical examples for you, whether you're in a small or medium-sized firm or even in a large firm, particularly as you try to manage sensitive data about your clients' clients or their employees or your own employees, as well as dealing with third parties. Things to think about when adopting new technologies like AI or cloud-based tools. Our goal is to try to give you a realistic, actionable steps to help you comply with the ethical rules while protecting your clients and your firm. Just in terms of next steps and what we're going to cover, we're going to start by trying to identify some of the sensitive types of data that law firms deal with routinely and the associated legal, ethical, and operational obligations that you have. We'll dig into some practical risk reduction strategies. First, those that deal with data minimization, talk a little bit about that, talk about some things that happen inside your firm, as well as things that happen outside your firm that you want to be mindful of. And again, as I mentioned, we're going to try to work in references to the Florida bar rules that will be important, including the guidance on AI, which came out recently, in addition to the recommendation that Kevin mentioned. So hopefully you'll leave today with some helpful best practices to apply in your own firm, and maybe also not just with clients, but also in the administration of the firm, which is also important. Um, so just moving on, I'll do a little bit of housekeeping of our own, right? The first thing that Kevin mentioned earlier was the CLE course code. You'll see that there. You'll need that. The number is 9195. So just jot that down. Um, you know, One of the things that we see is the professional rules of ethics require attorneys, as we all know, right, to be competent, and that includes with respect to the technologies that they are using to provide legal services. And also, it doesn't really stop there, right? Not knowing about that is not enough. If you need help, you have to go get that help. Um, this is an opportunity to get some of that help, to get some of that information, but also to document when you've done so, right? You're going to want to show whether it's for the rules of ethics or for some compliance obligation that you have. You'll see that as a business, you have obligations to safeguard data. And part of that obligation is to conduct some type of training and security awareness that needs to be part of your business. And, when you do that, you really want to be sure that you've documented that you've done that training. And there really isn't any right or wrong way to document training. There are some good things you want to include, like what the time and date of it was, who in your firm, including you, attended, and maybe some evidence of what information you covered during that training. And I know that this slide deck will be available. So just as you kind of manage your own internal documentation of what you do to comply, this might be part of that effort. So you want to think of this as kind of like just not just the CLE and the kinds of credit, but just as part of your security and awareness program for your business. So just kind of moving on to more of the substance. You know, One thing that I think just at a high level, law firms, at least the ones that we've worked with, not all of them, but some of them, they they don't necessarily always think about how deep the type of data that they get or how the nature of that data can affect what their obligations are. And that really is more of the point. You may have one type of medical information that could fall into a bunch of different frameworks and create different obligations, right? So as firms, we're custodians of sensitive information as well as business information that pertains to our clients, our employees, witnesses, third parties, a whole host of different cast of characters, as well as other information that we collect when representing clients and running the business, as I mentioned. Think of a typical civil litigation. You might have a client's medical information, could be PHI, it might be substance abuse information that triggers a different set of rules, could be employment records, might be personal texts that have sensitive data in them. And in all of those circumstances, it's confidential information when it's in the client relationship. But that information also may fall into different uh, federal, state, local regulatory obligations and frameworks that you need to be aware of. And this is really the case with any area of practice, right? If you're in the real estate or you do trusts, you might get tax identification numbers. You might get a lot of bank account information or financial account information. You might get copies of wills that have sensitive family data. If you handle employment law, you might wind up with disciplinary files or performance reviews or benefits information, where again, you're getting pretty sensitive data about individuals. but also think about your business. If you have employees, if you have staff, however, if they're contingent staff or what have you, independent contractors, in order to pay them, you might need some sensitive information about them. If you provide benefits, you might need some information about them. So there's a whole cadre of different types of personal data, and they come with different names. And I think we all kind of just refer to it as, well, personal data or personal information. And we don't think that those terms have specific meanings. And so the point of this slide is to really kind of just walk through a couple of these different examples so you get a sense that when you use a term, generally that may be fine, but you want to always be mindful that when I say personal information or when I say personal data or when I say protected health information, those terms really may have a specific meaning. So just generally, right, personal information or personally identifiable information, that could mean any information that's identifiable to an individual. And we see that in statutes like the CCPA and the 19 or so other states that want a very broad protection for consumers. And we'll see that as, you know, law firms could find themselves having obligations under those statutes, even if they're not a business directly, but we'll get to that. Um, but you might have more, narrower categories. So protected health information is really a term of art under the HIPAA rules. So if you happen to be doing medical malpractice information and you're representing hospitals or providers, protected health information might be pretty important because you're getting that and you're probably a business associate. And so you want to be thinking about that because not all medical information is going to be protected health information. Good example of that is if you have an employee that wants a day off, or you represent a client who has a question for you about one of their employees who wants a day off, and they share with you medical information about that employee, that's probably not going to be HIPAA protected information, even though it's medical information. You might consider that to be confidential medical information. That's usually the term of art that's used in the context of the ADA. So if you're dealing with an employment situation internally or with a client, and it's a leave of absence or an accommodation, it's probably going to be confidential medical information, not protected health information. Personnel information tends to be a broader term, and it could include a whole bunch of different things. But what I think a lot of clients think about when they think about personal information for their own business and for their clients is, information about the personnel file. But sometimes not all personnel files are created equal, and so you could have information in there that you didn't expect. The last thing I'll mention about this is we also don't want to forget confidential business information, right? As lawyers, we're not just worried about personal data. We have obligations with respect to confidential business. And so when we go down and talk about privacy, that's going to typically be with respect to individuals and their privacy rights. But when we talk about cybersecurity and just securing data generally, we want to think about confidential business information as well. And so with that, I wanted to just turn it over to Damon, who's going to talk about data minimization and how we address and maybe even minimize some risks if we think about some of these principles.
Yeah, thank you, Joe, and hi everyone. Thanks for taking the time to join us today. There's this concept of data minimization that really can be quite effective in helping law firms, along with various other types of businesses, including many of your clients, to better manage their data privacy and security risk. And data minimization is a concept that has existed for a while in Europe. It's existed in certain corners of the US. Joe mentioned HIPAA. HIPAA does have a data minimization requirement, but it's not something that most US organizations until recently had really given much thought. In fact, I would say the trend really in the US in recent years has been more towards gobbling up as much data as possible in order to get insights into our clients, our employees, our website visitors, and other data subjects. More recently, the last couple of years, in order to train the large language models that AI tools are built on. For several reasons, though, this gobbling up of data without adequate consideration of data minimization has become increasingly risky. One reason for that is that some of the state privacy laws that Joe mentioned, such as the CCPA, specifically have data minimization requirements. In the EU, the GDPR does as well. We've seen thousands of claims asserted alleging violations of website tracking of laws based on the use of website tracking technologies. And in many cases, the claim is that those technologies are collecting all types of information about visitors to websites and then disclosing them to outside parties like Meta or Google. There have already been a few states that have passed AI-specific laws that do touch on the issue of data minimization, and we anticipate that other states are going to follow suit in the not too distant future. And then looking at data breach risk, the cost of responding to a data breach continues to go up year over year. We've seen way more class action litigation resulting from breaches, and paying inadequate attention to data minimization expands your data breach footprint. Joe and I and other members of our team have handled a lot of breaches where at least some of the impacted data was data that our client had essentially lost track of, therefore had not adequately secured, and in many instances didn't even really need to have. So what exactly is data minimization? So in the context of data collection, when you're first taking data into your firm, it means having a process in place to only collect and process the data that you need for a specifically defined purpose. So if we take the context of a litigation or an investigation, and you're talking to the client, and the client mentions documents and spreadsheets and other materials that might be relevant to your case, it means being somewhat thoughtful about what you actually need rather than just saying, send me everything. Or if you are going to ask for everything pretty quickly, making a decision about what you need to keep. If the client's going to send you a spreadsheet that has a long list of individuals with social security numbers or some other sensitive element, unless there's a really good reason to continue holding on to that in your systems, it's probably not something that you're going to want to do. And the same is true. I sort of touched on this in mentioning data breach risk, but the same is true of your retention periods. You may have had a good reason to collect data at some point in time, but perhaps that reason has passed. You've done whatever you initially intended to do with that data, and maybe now at this point, you no longer have a justification for continuing to keep it, and you're going to want to look into either archiving or purging that data.
Damon, can I ask a question
Of
that
course.
comes up plenty? Thinking about really practical in law firms, and we've talked about data mapping in other webinars that we've had, but a lawyer may collect information. And so, what are your thoughts on is that information? It may first be in an email, and then it might get saved on someone's computer, and then it might be on someone's own storage system, whether it's iManage, NetDocs, or something else like that. Are there things attorneys should be thinking about in terms of where things are saved or how much they're saved?
Yeah, absolutely. That's a great question, Kevin, and definitely something we'll touch on with some of the examples that we go through later in the presentation. But yeah, I mean that is a big challenge from a data mapping perspective, is that you may have data coming in from various different channels, you likely do, and that data you may have a great case management system set up that has encryption and has access controls, but maybe that data never makes it into your case management system because one of your attorneys receives it by email and knows it's in their email and just assumes that whenever they need access to it, they'll get it from their email, or they save it locally to their computer and they access it that way. Or you could have situations where the same data is saved in lots of different places because you have someone who got it by email and they saved it locally, and they also saved it in your case management system, and they also emailed it to other people within your firm. And so now, if you're talking in particular about any information that's sensitive, you might have 7 different copies of that same information, which definitely heightens your risk of a data breach because maybe that breach will impact certain email accounts but not others, or certain applications but not others. And it also makes some of the stuff we're going to talk about from a privacy perspective challenging, because without knowing what data you have and how you're using it and how long you're keeping it, you're not really able to comply with a data minimization mandate. You might not be able to make the disclosures that you're required to in your privacy policy. So it has a lot of implications.
Thanks. Well, I can always keep asking questions, but I'll let you keep going.
If you have more, by all means, go ahead.
Yeah, no, go ahead.
Um, so that actually is a very good segue to the next slide, Joe. So within your firm, you likely are using a variety of different technologies, and getting an understanding of those technologies is going to be very important to having an effective data privacy and security program. So one technology you likely utilize, which I just mentioned, is some type of case management system, likely that is cloud-based. And through effective policies and procedures, you can take steps to ensure that you are leveraging the safeguards that these systems will typically make available to help you to protect your data. So for starters, and I just mentioned this point, but I want to reiterate it, you really do want to make clear to your attorneys, your administrative staff, that they are required to take data from whatever channel it comes in, be it email or over the phone or by some other means, and they need to get that into your case management system or wherever you have designated as the place that you are going to store that type of information. Because oftentimes, if you're using some type of cloud-based platform, you will have the option of putting safeguards in place like encryption and backups and audit controls. But if your data is never getting to that secure location, then all those safeguards are not really doing you a whole lot of good. Another key consideration with respect to these platforms is access management. Likely your case management system is structured so that different clients and different matters have their own workspaces. But it's not unusual in the case of some of the clients that we've worked with and businesses across the spectrum to have a lot of people have access to those workspaces that don't really have a real business justification for having that access. And it may be the case that people can, directly go to that workspace, or if they run a search, it pulls from that workspace. But you do want to be thoughtful about who actually needs access to what data. And although it might seem like the path of least resistance to just say, well, all my lawyers might need access to this, it might help them in some way, you're creating quite a bit of risk by doing that because, say, for example, one of your attorneys clicks on a phishing email and someone gets access to their credentials, and that person can access any data related to any of your client matters. Potentially now the bad actor that got access to your attorney's account is going to be able to completely wreak havoc and get access to everything within that's being stored in your information systems. Particularly if you have employees that are accessing the case management system from outside your office, either from home or when they're traveling. You also want to think about what you have in place in terms of access controls or what you could have in place in terms of access controls. So multi-factor authentication, for example, is often a tool that's made available to secure access, but too many organizations realized too late that multi-factor authentication was not actually enabled for the application that ended up getting impacted by the breach. And as a result, the bad actors were able to get access even though you didn't think they would be able to. Another feature of a case management system that it's important to understand and leverage is audit controls. And what that refers to is the logs that your system maintains of activity within the system, like who accessed which files, when they accessed those files, whether they exported them, whether they edited them. If you have a data incident or if you're doing some type of internal investigation of an employee wrongdoing, these logs can be really helpful and they can put you in a much better position to narrow down what happened, which, if you think about it in the data breach context, could be the difference between only having to notify and report with respect to a handful of specific files that were interacted with versus having to assume that everything stored within a certain workspace or even an application could have been impacted because you don't have evidence that the incident was more limited. Moving from case management systems to personal devices and bring your own device programs, many firms permit employees to do work on personal phones, tablets, laptops, home computers. And these programs are often mutually beneficial. They can save firms money, they're popular with employees, but they do need to be carefully managed. For instance, it's very important to maintain an inventory of the devices that are enrolled in your BYOD program, since these devices are now storage locations for your personal and other sensitive information. And you want to be able to keep track of all of those devices, and also be able to see whether you're comfortable with the security settings on those devices. So from a security standpoint, one thing you might want to think about if you do have employees using personal devices for work is whether you want to have them use some type of mobile device management solution, which basically allows you to have control over the data, even though it's on someone's personal device. So, for instance, if your employee loses their device, or if they leave the company on bad terms, you want to be in a position to one, continue to have access to this data, but also potentially, remotely wipe the data, lock down access to that solution so that the data is no longer at risk. You really don't want to be in a position where an employee loses a laptop and you have no idea what was on it, you have no ability to wipe it, and you basically, again, are in one of those scenarios where you have to make broad assumptions about what data could have been impacted as a result. Your firm may also use remote work and collaboration platforms like Box and Slack. And many of the same considerations we've already discussed are going to apply to these platforms as well. You're going to want to think carefully about who has and who needs access to information stored in the platforms. You'll want to ensure you have passwords, multi-factor authentication, and other mechanisms in place to secure the data that's going to be processed on these platforms. You'll want to look at the default retention periods for data on the platforms to make sure it aligns with your record retention programs. And you also want to confirm that there's going to be sufficiently detailed logging of activity within these platforms so that you have visibility into how your data is being interacted with. Last but certainly not least, it's important to get a handle on the AI tools that your firm and its employees may be using. To give a few popular examples, one would be tools that can review documents and summarize them, or pull out specific information. One thing to think about with these tools is that if the documents at issue store personal data or sensitive client data, there's potential risk in the use of these tools to summarize a document, because the data from within those documents may be used to train the underlying models, and that data could then be leaked to some subsequent user of the tool. Another popular AI-powered tool is meeting assistants, meaning chatbots that join a Zoom meeting or Teams meeting and create transcripts and to-do lists from the meeting. These are certainly very helpful. They can be very useful. They're a technology that we've been asked a lot about by our clients, but they present a number of risks that it's helpful to think through and try and mitigate. So one of those risks is the oversharing of transcripts, which could compromise attorney-client privilege. It could create data breaches. So, depending on what tool is used and how it is set up, it may be the case that a transcript will automatically go to everyone who is invited to or who attended a specific meeting, even though that may not be the intent of the attorney or other member of your firm who's using it. Maybe they thought that the transcript would only be sent to them specifically. So that's definitely something to take a look at if these types of tools are being used. Another risk with using these tools is that depending on the locations of the people who are participating in the meeting, there may be an obligation to get consent from those individuals to record their communications. And if you have these tools being used just sort of on an ad hoc basis by whatever attorney thinks they might be helpful, odds are you have not set up a mechanism to provide notice and collect consent. The meeting assistant may also collect extraneous information that a human note taker would not. So for instance, the first couple people that join a meeting may just be talking, sort of off the record about what they did the last weekend. their upcoming medical procedure, something related to their religious beliefs, their political beliefs. There's a lot of content that people may talk about before or after a meeting that they would not expect to then have as part of a transcript, particularly one that is circulated to everyone who was invited to that meeting, even if those people were not on at the time of that discussion happening. And I talked to a client recently who had an issue with this where a couple people were early to a call. They were bad mouthing one of the people who hadn't yet joined the call. Eventually, that person did join. They had their regular meeting, and then afterwards, a transcript of everything that was discussed, including that early off the record part, was sent out to everyone. And obviously, that created some interpersonal tension between these employees. Last point on meeting assistance is that you also want to think about from an ESI cost and burden perspective, whether you're comfortable having transcripts of all these meetings being created. Because you could have a situation, maybe it's a legal malpractice claim, or there's a government investigation of a client's fraud or criminal conduct, where all of a sudden these transcripts might be discoverable, and you might have a much heavier ESI burden than you otherwise would have if you were still dealing with a situation where people were only manually taking down what they thought was most important from each of their meetings. Last note on AI tools is, increasingly firms have started to use a variety of tools to monitor their employees' productivity and their compliance with firm policies. And these tools can capture a ton of data. Some of them take regular screenshots of whatever's going on in the employee screen, including their personal emails, their personal chats, their web searches. Some of these tools will log keystrokes. And we've talked to numerous clients that didn't realize the full scope of what these monitoring tools were doing and hadn't put guardrails in place to ensure that that they were managing all of this information in a way that did not expose them to unacceptable levels of privacy and security risk. So definitely something to be mindful of. And if the tools are AI powered and you're using them to make employment decisions, you might also have obligations under some of the new state AI laws that we mentioned. Next slide, please, Joe. Okay, so to flesh out some of the concepts that we've been talking about, we wanted to just give a couple examples, a couple of hypotheticals. So in the first hypothetical, a client texts you a picture of their IRS Form 1040, and you could obviously substitute in various other documents that store PII here. So then what happens next? Ideally, you're going to move, and this goes to the question that Kevin asked earlier. Ideally, you're going to take that document and you're going to move it into a more secure location, like your case management system, and then you're going to delete it from your text. You may also need to delete it from your photo roll, and you also may need to delete it from your personal email because odds are, in the course of trying to get that email from your text into your firm email or into your firm CMS, you first attached it as a personal email and then email it to yourself at your firm email so that you could then move into the CMS. So you do want to think about it as clients send you data via different channels. You do want to think through the sequence of where that data could end up and make sure that you've addressed each of those instances of the data potentially being stored. Another common hypothetical that we touched on in the last slide is, one of your associates, another attorney at your firm, invites an AI meeting assistant to a client meeting. And this might be a meeting that, the associate's handling by themselves, or may not be any partner on the call who even realizes that the meeting assistant's being used and is creating this transcript. And so, the issues that we talked through on the last slide are going to apply in terms of making sure that you got consent and being mindful of what might be in that transcript and where you want it to be stored and who you want to have access to it. Probably the best known of the AI products that have exploded in popularity recently is ChatGPT. And there are similar tools like Claude, Gemini, and Perplexity that are very popular as well. And these are all chatbots that can, in response to prompts, including attached documents, rapidly generate very polished and apparently credible work product. Given these capabilities, time-crunched or just corner-cutting attorneys are going to be very tempted to use these tools to generate client work product, including work product like a case assessment memo that might be tailored to the facts of the specific client's case. And it might be possible, it probably is possible to artfully craft AI prompts that are both specific enough to generate the tailored work product that the attorney needs, but vague enough to obscure any client identifying information. But I think we're all likely safest operating from the assumption that our attorneys are not always going to be capable of or willing to take the time to skillfully navigate those competing considerations. And more likely, if they need to err in one direction, it's going to be towards the option that takes less time and requires less effort. Another challenging scenario is your attorneys forwarding client emails to their personal email accounts. So, say you have attorneys that are traveling or they're working from home, and particularly if they're working from a personal device, they may encounter technical challenges accessing materials that are stored in your systems. And if they do, a pretty common self-help remedy is to forward those materials to personal email accounts so that they are more easily accessible. The problem with this, of course, is that your firm data is now stored in your employee's personal email account and is no longer under your control and is no longer protected by the safeguards that you put in place to protect that client data. Another popular technology that may be in use by your firm is Google Translate and other similar freely available translation tools. For instance, you might have a scenario where after interviewing a witness in Spanish, one of your attorneys turns over their notes from that meeting to their assistant to be cleaned up and translated into English so they can be shared with a client. Google, or whatever tool you use, now has access to everything that was entered into the translation tool. And if any of the information that was entered was client sensitive, that information is now again beyond your control and outside of your safeguards. In our last hypothetical, you have an attorney who uses her personal Dropbox account with default sharing to transmit documents related to a case. In doing so, it's possible that she thinks she's doing the right thing from a data security perspective because sharing via Dropbox is likely to be more secure. It might have encryption and other safeguards than transmitting it by email, and perhaps your firm doesn't have a corporate Dropbox account or an equivalent. This scenario, though, poses several problems. The first of which is that, again, you now have one of your attorneys who has client materials stored in their personal account. You no longer have control of those materials. They're no longer protected by your safeguards. In addition to that issue, depending on how Dropbox, how their access controls are configured, these files may now be susceptible to much broader disclosure than was intended. For instance, it may be the case that the link that was generated when your attorney shared the files via Dropbox can be accessed by any person to whom that link was subsequently forwarded, or even by a bad actor who gains access to the account of one of the recipients of that link. Next slide, please, Joe. Okay, so very quickly, because Joe's going to talk about this a little bit more in a couple minutes, but I wanted to flag a few high-level issues to be mindful of when your clients propose engagement letter revisions or addendums or send you their outside counsel guidelines. If your client's in an industry that's heavily regulated from a data privacy and security perspective, healthcare, financial services, insurance are a few examples, the client may attempt to push down to you by contract obligations to which it's subject. For instance, a healthcare entity subject to HIPAA might propose a business associate agreement, which might be appropriate under the circumstances, but you're still going to want to understand the specifics of what the client has asked you to represent you have in place to ensure that it aligns with your actual data security program. Even if the client's not mandated by a framework like HIPAA to push down certain contractual obligations, you're likely going to have clients that, as a best practice, seek to impose certain obligations or limitations on how you handle their data. So, a couple common examples are that they may prohibit you from storing their data outside of the U.S. They may require you to store it, on your own servers. They may specify certain safeguards you need to use, like MFA or encryption. And they also may seek to reserve the right to audit your data privacy and security program, and they may impose requirements related to data archiving and destruction at the end of an engagement, at the end of the engagement that prompted them to give you the information in the first place. So our next topic is ethical rules, and for that discussion, Joe, I'll turn it back over to you.
Thank you, Damon. That was great. Before jumping into that, I wanted to just kind of talk about just a quick real life example that I think pulls in a lot of the issues that Damon kind of discussed, and that is, from data minimization. This is a case that we had of a law firm that had become a victim of a cyber attack, and the bad guys got into their environment. These were all relatively small firm, maybe 15 to 20 attorneys, and they had saved in their environment that was compromised a document that had all of the employees' passwords and usernames for court filing systems. So when the bad guys got in through a phishing attack, they were able to they searched for, able to find this document, which, one thing to think about is from a data minimization perspective, do you want to have on your systems, keys to the kingdom for everybody in one place? And that's kind of what they had. And what the threat actors did, they didn't just, look at that and try to get some ransom for it. They actually logged in to the court systems and then began to share with the law firm's clients the client data. Now that data had been filed with the court, but the fact that these bad guys were communicating with clients created a real interesting wrinkle to the incident response process of that law firm, right? So you start to think about, Damon talked about remote workers and data minimization. This really does happen and can create some pretty difficult situations for firms in particular when this happens. And it's because, sometimes data that you don't want to have left on the systems is there. It's important to really think about and how these situations can apply in the real world. Moving forward to some of the really critical ethical rules we have to contend with, and again, that's just kind of another point. Is I think a lot of what Damon was talking about was some really good risk management steps that you can take in a law firm or really any business. I mean, these are things that a lot of our clients, not just law firms or accounting firms or other professional service providers, think about. But as lawyers, right, we have more specific rules to contend with than most other businesses. So the Florida Bar has made it clear, as the model rules and just about every other state, that we have to be competent in our practice and our representation, and that includes understanding how technology affects our legal duties. Rule 4.4-1.1 includes a technology competence requirement, and that basically means that employers have to understand, at least at a basic level, how the tools that they use, some of which Damon discussed, affect confidentiality and client representations. And just some of the commentary under that rule states that competent representation means may involve the retention of a non-lawyer advisor. You may not understand everything. AI is complex. Some of these systems are complex, and if you don't understand it, it may make sense to get a non-lawyer to assist. And that competence also includes safeguarding confidential information relating to representation, including, without limitation, electronic transmissions and communications. those comments go on to say that a lawyer should keep abreast of changes in the law. And there's been a lot going on, particularly in the AI space, but also in the data privacy space. As we've seen, many states have adopted data privacy statutes. Now, Florida did as well, but it applies to, I think, entities with revenues in excess of $1 billion. And, it may be that you may not be subject to that. Um, Congratulations if you are, right? If you're doing $1 billion in revenue, right, as a law firm, that's great. But you may be representing a company that's subject to that law or in other states, right? And may have to think about the rules that get pushed down through these new developing laws that the ethical rule requires you to keep abreast of. Rule 4.4-1.6 governs confidentiality, right? And that extends to third-party tools and platforms. So if you're using cloud storage or email or AI tools, you need to take reasonable steps to preserve client confidence. Um, in this area, it really is important to think about trust but verify. A lot of what we do and a lot of businesses do is we rely on third parties. Damon started to get at that on his last slide. But again, it's a really important thing. We see a lot of vendor data breaches, and we trust. We think, oh, this is a big company. Maybe you're a 2 or 3 person law firm, and you're about to purchase services from a vendor, and they have locations in all 50 states, and you think, they must know what they're doing. It's not always the case, and it may sadly more often than not be not the case. And so your job isn't to, conduct a full-scale audit, right? No one's going to be able to do that, but you have to do some verification. You have to do some assessment of your vendors to be able to get at least a reasonable assessment that the data that you share with them is going to be safeguarded. Um, of course, um, you may find yourself trying to defend your business reputation. So it doesn't always happen with a third party. You might sometimes be your worst enemy. An example of that is if suppose you see some comment on a review platform, Google reviews, or someone starts commenting about you and your law practice online in a negative way. Maybe they say things that are incorrect and defamatory. And of course, you want to try to respond to that. Responding to those raise some serious confidentiality issues. There are some exceptions. They're limited to that rule, such as if they make specific allegations online, a former client does that has specific criminal conduct that's punishable by law. But if you respond to other things, you really want to proceed pretty carefully, if at all, in those situations. And I think while it's tempting to do so, it can create some significant liability, not just from the bar. We see this with healthcare providers that if they disclose that information, there's been some enforcement actions because they're disclosing patient data. And so if you happen to be in a situation, you might not think about it, you haven't thought through the business associate agreement, and you respond to a client that was involving a matter that involved HIPAA protected information, you could violate HIPAA as a business associate and be subject to those same types of enforcement actions, which have resulted in fines of tens of thousands of dollars. So, getting involved in that type of activity could result in a violation of confidentiality. Another important rule is 4-5.2 and point 3, and that really deals with supervision. Partners really, as you know, have to have some supervision over staff and associates and younger lawyers, including even non-lawyer vendors, to understand and follow the rules regarding confidentiality and data security. This includes things like paralegals using online cloud tools. And also, remember, Florida has some pretty specific rules around marketing and solicitation. So if you're dealing with marketing assistants and so on, it's not just about the actual solicitation, it's also about the data that's used in that process. So you want to be thinking about that as well as you supervise those activities. And also IT and administrative access to firm systems. Those are things that, again, you want to be thinking about in terms of supervising legal and non-legal staff. And it doesn't mean, micromanaging every task that's performed, but it does mean, going back to the first slide, right? It does mean some type of training, having policies in place, and following up. Um, Florida,
I have a question. Well,
yeah.
it's sort of a question because being in the Cybersecurity and Privacy Law Committee, we've talked a lot about the rules that regulate attorneys. And I feel like this analogy has come up, and I'm curious just whether you think it is useful. We've said, an attorney's duty to manage data privacy and cybersecurity can often be compared maybe to something like accounting. You know, Lawyers have a lot of responsibilities when it comes to managing the finances of their firm, trust accounts, what they have to oversee. A lot of lawyers, will famously say, I'm not good at math. I don't like dealing with that. But at the end of the day, you do have to make sure you understand the money going in and out of the firm, how the trust account's being managed, making sure that it's appropriate. And I tend to think it's a useful way to think about data security. It's like you probably won't be an IT expert and you probably won't be a cybersecurity expert as an attorney, but there's still a lot you have to continue learning and delegating that often to, as you might with an accounting firm, you might also be hiring an MSP, a managed service provider, an MMSP, security service provider. Um, do you think that's a useful analogy? And I say that because these ethical rules are still kind of being parsed out as to what's the duty.
Kevin, I think that's a terrific analogy. And just to kind of take it one step further, we are seeing, and some of the folks on the call who have employees may have benefit plans, right? And they may not realize this, but to your point, under ERISA, DOL issued guidance that says you have a fiduciary duty to assess the cybersecurity of the vendors that provide services to your retirement or your health and welfare plans. And a lot of, even in small and mid-sized, mostly in small and mid-sized companies, you talk to fiduciaries for those plans. They're used to looking at the investment performance of their 401k plan. And then you come to them and say, well, you now have to assess the cybersecurity of your vendors. And they're like, well, I'm not an IT, I don't know that. I look at the investments. And you're like, well, in this role, to your point, Kevin, you need to go figure that out. Doesn't mean you have to become, a cybersecurity expert, but it means as a fiduciary, you have to get somebody who can help you understand. And so that as a fiduciary, you can make that decision. And that doesn't always mean necessarily making the right decision. It means what's the process? Did you engage in an appropriate process that's reasonable to be in a position to make a decision like a similarly situated person would be able to make? So yeah, whether it's looking at finances, looking at cybersecurity safeguards, all that, it's your business. And that's the other thing. Look, this is your business, right? So you should want to preserve it because in some of these cases, these data breaches can cause significant damage and it could substantially impact profitability. And so, it really goes to some important considerations even beyond the ethical rules.
Well, and there's the plug for our next webinars. We are looking to have webinars on selecting an MSP for a law firm. And then our next webinar is also about cyber insurance. So keep staying tuned in, people, to be learning more about these things.
Awesome.
Pass it back to you.
Um, so just quickly on there's a couple of recent there's one ethics opinion by the Florida Bar on AI. And again, I'll just quickly go through just some thoughts about that. That's a really good read if you're using AI. It addresses a lot of things. It talks about how you should think about sharing information with your clients about the use of AI, how you should deal with advertising. But again, a big focus is on confidentiality. And so you want to be thinking about what are some of the best practices. It recommends alerting clients that you're using these tools. So you really want to look at that opinion. And then I won't spend a lot of time on this either. You can take a look at what Kevin shared, but recently the Florida Bar issued a recommendation for incident response plans. We've talked a lot about trying to minimize those risks, trying to prevent harm, trying to minimize your data footprint, right? But stuff happens, and you have to assume that it will happen to you at some point. And at that point, when it does happen, it happened, and you just need to be prepared. And that's what incident response plans are about. The article that we went through summarized some of the key things that should be in an incident response plan, but it's not even just about having the incident response plan. You really want to think about, practicing that plan and having been through that. for clients and dealing with our own issues as a firm, I can tell you that being having gone through those tabletop exercises can really help you when you have to make decisions really quickly. And communications are going to be very difficult, particularly for law firms with clients when their data is impacted. So having thought about that ahead of time and having some strategies for responding to an incident like that and dealing with clients and their data and what steps you may want to take, as a client relations from a client relations standpoint is really best thought through beforehand. Uh, just to kind of talk through this last slide, I'm going to turn it over to Damon to close us out. In the contracting process, we are seeing a lot of uh, a significant increase at our firm, not only on clients asking us to sign privacy and security addenda, but actually going through an assessment process before we even get the work. So at the procurement stage, we're doing risk assessments and trying to respond to those risk assessments. And you may do that yourself. You may have your third-party IT firm do that. Whoever's doing that for you, those assessments and how you respond, you really want to look carefully at those responses because if they're inaccurate in some way, it could come back to haunt you. If you say, well, we've never had a data breach, but you really never thought about that. What is a data breach? Are we answering these questions accurately? Do you have multi-factor authentication? You don't just want to check yes if it hasn't been pushed through to everybody, right? So you really want to think about how you're responding. I just signed an engagement letter this morning with a client that asked about AI use and how we need to get approval and what they expect from us as their law firm. I can tell you these provisions, including the privacy, are getting more complex. So review your own engagement letters to see how you can clarify what you're doing, how you could kind of get ahead of this and put in some provisions that make clear what your firm does. So addressing the Florida AI opinion. Think about how we can share information about how we're practicing law and what technologies we're using. And lastly, just you may want to think about, does it make sense to have policies or even an agreement with employees about what your expectations of them are before they leave and after they leave? How do you get that data back from them if information's on their device? There's a lot of things to consider. You may have an employee that runs your social media page and communicates with clients on your behalf, and that's really their account. And if they leave, it's still their account. And you may have difficulty getting access to that account and all of your clients' contact information. So these are some things you want to think about when it comes to dealing with employees. So Damon, I'm going to turn it over to you to take us through the end.
Yeah, Joe, you mind just jumping into the last slide there, number
Yeah.
12? Okay, so Joe and I have covered quite a bit during the program today, and we wanted to tie it together a little bit and leave you with a few key takeaways. So one, and this ties back into the great question that Kevin asked, that it's an important thing to think about is whether you really have an understanding of your firm's data. Have you done data mapping exercises so that you can identify the data you're collecting, understand who it relates to, how it's being used, where it's being stored, what technologies are being used to process it? That really is going to be the foundation for an effective data privacy and security management program. Another key takeaway, which Joe was just discussing, is that it can be beneficial. It probably is going to be the path of least resistance for you to be transparent with your clients about the technologies you're using, the privacy practices that you have in place. Clients are increasingly going to want to ask about that. And if you can be out front and show it's something you've already thought about and tackled in a way that is thoughtful and gives them confidence, that's certainly going to be beneficial to you in building business and will cut down on back and forth with clients over the specifics of those provisions of your agreements. It's also important, particularly as technologies continue to come onto market, as there's lots of different vendors out there that are offering services that may be of interest to your practice, that may be of interest to specific lawyers at your practice, even if the firm as a whole has not adopted them, to regularly review what specific tools people within your practice are using, what are the use cases? Are you comfortable with those tools and those use cases? For each of the developers of the tools, are you comfortable that they are going to be a trustworthy steward of your data? Have you looked at their terms? Do you have a DPA in place if that's appropriate because they're going to have access to your data? Training and supervision of staff always going to be important, particularly again with all of the change that is regularly happening in this space, making sure that people are aware of what your policies are, what your expectations are. In the case of an incident response plan, who they should report a potential incident to, what should be done to avoid compromising forensic evidence, and then the last point is documenting decisions, particularly related to the technologies you're using, the vendors you're relying on. Because it may be the case that at the time you engaged a certain vendor or started using a certain technology, you did have some thoughtful deliberations in place and you reached a comfort level with that technology or that vendor. But if you don't create documentation to show that, by the time there's some type of incident, you may not remember exactly what the deliberations were, and you're certainly not going to be in a good position to demonstrate to a government agency, say, that you engaged in those deliberations. So that brings us to the end of our program. Thank you all again for taking the time to join us, and please don't hesitate to reach out to Joe and me and Kevin with any questions that you may have.
Absolutely. And Joe, you could put back up the first slide because I know it has your contact information in case anyone needs it there. But thank you for everyone attending. I know everyone's probably got work to get back to, so thank you for spending your lunch hour with us. And the Cybersecurity and Privacy Law Committee will be continuing to have webinars throughout the year, so look out for those and to be able to continue learning and getting CLE credits. So thank you everyone for attending today.
Thank you.